So welcome to the third in our series of property law seminars produced by the real estate team at St Philip's Chambers this March. The aspect which all three of them so far have had in common is a focus or a touching upon of the subject of adverse possession. And my theme today is how much is too much, and looking at in particular the boundary condition, but not only the boundary condition. I will touch upon the other conditions in relation to adverse possession. And that's really a discussion about the context of reasonable belief that the land in question, the specific land, belonged to the applicant. And I will also attempt to draw some of the strands of the earlier talks together in the first parts of this discussion. If there are any questions arising from people who have joined us who want to raise any particular points, and I'm going to ask you to put it in the chat, and I will look at those at the end of the seminar and respond at that point. I want to start though with just a quick review of the relevant law. I think this is useful because the concept of adverse possession wasn't changed by the Land Registration Act 2002, and in some respects it's deceptively simple. The first requirement for adverse possession is of course factual possession, and the most authoritative case in relation to this is actually a case called Pye and Graham from 2003, which cites extensively from a very influential case called Powell and McFarlane from 1977. So factual possession signifies basically physical control. It has to be single and exclusive. So the squatter and the paper title owner can't be occupying the land at the same time. Obviously, it wouldn't be adverse possession if it was consensual either. And the questions of what acts constitute a sufficient degree of exclusive physical control must depend upon all the circumstances, in particular the nature of the land and the manner in which land of that nature is commonly used or enjoyed. And the alleged possessor has to be dealing with the land in question as an occupying owner might have been expected to deal with it, and no one else has done so. So obviously we might look at things like fencing, land in or enclosure. It's a very obvious one. Changing the surface of the land has become something of a theme recently in respect of, for example, small estates where block paving or something of that sort has been put down. But it all depends upon the nature of the land and the circumstances. So that's factual possession. Then they have the intention to possess, an intention in one's own name and on one's own behalf to exclude the world at large, including the owner with the paper title, who is himself not the possessor, so far as is reasonably practical and so far as the processes of the law will allow. So you've got to intend to possess the land, not to dispossess the paper title owner necessarily, but to possess the land in question. If, for example, you believe you own the land in question, then that will readily fulfill that requirement. Sorry, going ahead too fast here. Manifest intention. So this is an aspect of intention, and the intention to possess must be manifest to the legal owner were they to attend upon the land and see what was taking place. And you can see that these aspects of factual possession, intention to possess, and that intention being manifest are all very closely related and to some extent overlap. So a person seeking to possess an owner must, in my judgment, and again this is on Powell and McFarlane, at least make his intention sufficiently clear so that the owner, if present at the land, will clearly appreciate that the claimant is not merely a persistent trespasser, but is actually seeking to dispossess him. Those are the rules. 12 years of adverse possession is still required in relation to unregistered land. But in relation to registered land, a 12-year period would have to be in before the 13th of October 2003. So that's a 12-year period current for unregistered land. The reason for that is that unregistered land, the process of possession and having been in possession for significant periods of time is a way of, if you like, demonstrating proof of title. It's the old adage that possession is 9/10 of the law. Of course, one of the reasons why the 2002 Land Registration Act was introduced was because that was a rather antiquated concept. Once substantial portions of the land of England and Wales were registered, and now registration extends to beyond 90% of the land area. So proving title through possession has become very much secondary to proving title through reference to the registered title. And some of the abuses of the old system were readily apparent even at the time that the new Act was being introduced. So Pye and Graham, through neglect, a large field was lost to a farmer, a large field in the area of the Heathrow Airport, very valuable. And that went also through the European Court of Human Rights, so valuable. And then a case of Nasrullah and Rashid, 2018, fraudulent registration had taken place there, and the squatter, relying upon his fraudulent registration, had been there 12 years, and on the basis of that acquired the land by adverse possession, notwithstanding the forgery of signatures and the fraudulent arrangement. Although that's a 2018 case, that is a case which was dependent upon 12 years back from 2003. And it has to be said that in my experience, it's still fairly common for adverse possession claims to be based upon that 12-year period. But if you require any time after the 13th of October 2003, then the period for adverse possession drops to 10 years. But so long as the registered proprietor puts the adverse possessor to proof by filing Form NAP within 65 working days, that's 13 weeks, then the adverse possessor has to prove not only adverse possession for that 10-year period, that slightly reduced period, but one of three conditions. The three conditions were intended, in effect, to provide exceptions to the abolition of adverse possession. And in many ways, one can see why that reduction to 10 years and the residual adverse possession would still exist if you failed to take sufficient care of your registered title to keep your address up to date, or failed to provide sufficient addresses. Then one can see why the out-of-date information on the registered title should not protect the legal or paper title owner. It's worth bearing in mind that you can have up to 3 addresses on any single registered title, so it should be possible to cover virtually any eventuality. So the 3 conditions are in paragraph 5 of Schedule 6 of the Land Registration Act 2002. The first condition begins in subparagraph 2, and that can cause some confusion. And sometimes people, because the NAP form is not well drafted, people can end up ticking the wrong box. The land registry should be able to pick up which particular condition somebody is saying they will are putting proof to or require the squatter to prove, but mistakes do sometimes occur. Now, this seminar is called How Much is Too Much? And in fact, that question in certain respects applies broadly to all 3 conditions. So the first condition is on the screen at the moment, and it's effectively proprietary estoppel. It would be unconscionable because of an equity of estoppel for the registered proprietor to seek to dispossess the applicant. Now, one may ask, and it is regularly asked, what on earth that has to do with adverse possession? Because, of course, you can win a claim to land on the basis of proprietary estoppel, or use proprietary estoppel as defence, without any need for 10 years of adverse possession at all. Indeed, one of the most obvious examples of when proprietary estoppel can arise is one where there wouldn't be anything adverse in the circumstances. So, for instance, permitting use of land, say, for the building of part of an extension to a neighbour's property, just crossing the boundary modestly, and then trying to go back on the permission that was given, well, that would engage proprietary estoppel, but would not have anything to do with adverse possession and wouldn't require 10 years. So it's very difficult to understand quite why this needs to be put into the particular context of the adverse possession claim. Had you got the same position where your neighbour builds slightly over the boundary for their extension, you simply stand by and watch the work being done, well, again, that might not have any positive consent, so it could be adverse. It's very difficult to see why, if you just stood by, knowing full well what's going to take place, and you allow that to happen in the knowledge that it's trespass, why you would have to wait 10 years, or why the neighbour would have to wait 10 years before asserting an estoppel in relation to that. The Law Commission in 2001 seemed to take the view that, well, if there was 10 years, then that would be fortified by adverse possession. But it's not really very clear what the condition really adds. It seems to me that realistically it's included probably because the register is intended to be a mirror of the paper or the legal title, and inclusion might have been a desire to make sure that all its exceptions were located in one place. But in any event, it's not much used. And it could be said that there's a little too much adverse possession in relation to that requirement. The second condition has similar objections, really. The second condition is that the applicant is for some other reason entitled to be registered as proprietor of the estate. And the classic example given by the Law Commission in relation to this is to say, oh, well, if you've bought the land and you go into possession, but for some reason the transfer was never executed, then that would be a basis for an adverse, using the adverse possession provision. But it doesn't really stand up to much analysis, because the statutory bare trust could be invoked, and the rule in Saunders and Vautier so the person could call upon the title without having to wait 10 years if they're paid for the land and gone into possession. The other example, which is sometimes cited, is where land is given by will, beneficiary goes into possession, but the land is never assented. But again, if you're able to prove those circumstances, then it's hard to see why you need to prove 10 years of possession, or how proving 10 years of possession simplifies matters if you go under the second exception. In fact, the most common use of this second condition, in my experience, is a different one, and that is where somebody has accrued rights by way of adverse possession for 12 years before the 13th of October of 2003, and then applies either by using the wrong form or belt and braces using both forms, not only to amend the register in AP1, but in adverse possession, and asserting that they're entitled to do so under the second condition. And that was established in a case I was involved in, Balavens and Sartori, in 2014 in the High Court. It was also the basis of the decision in the first tier tribunal, Judge Michel in Holroyd and Gething. It's referred to in McGarry and Wade as the land registry practice. And then in Panathan and Poppet, Judge Cook in 2017 said that it was trite law and didn't even need a basis of reference to other case law, which shows a really remarkably rapid progress from the first time, I think, that there's any court decision on it to becoming trite law in the space of a mere 3 years. And then that brings us to the third condition, which is the one which gets most exercise before the first tier tribunal, Land Registration Division of the Property Chamber, and to some extent by way of defence in court. So the third condition is the boundary condition. It's got 4 numbered elements. The land to which the application relates is adjacent to land belonging to the applicant. The exact line hasn't been determined under the determined boundary scheme, section 60, and the rules applied to that. Then C, for at least 10 years of the period of adverse possession ending on the date of the application, the applicant or any predecessor in title reasonably believes that the land to which the application relates belonged to him. And then the 4th requirement, the land must have been registered more than 1 year prior to the date of the application. It goes without saying that B and D really need no discussion. They're simple factual matters which will be apparent from the register in any event. But you might reasonably ask whether the third condition was necessary either. The general boundaries rule could be deployed to make boundaries match features. So under the general boundaries rule, the plan attached to a registered title only shows general boundaries. The ordnance survey plans are typically used, sometimes with a surveyor being sent out to check the ordnance survey plan, and then the boundaries are typically drawn up to features which seem to reflect the features on the conveyances or the transfer of part to produce a plan. And of course, those general boundaries do not reflect the legal boundaries, and Gavin MacLeod in his seminar dealt with this in considerable detail. The result is that ordinarily you have to go back to the earlier conveyances to establish the legal boundary. But nevertheless, the general boundaries provision is such that most of the boundaries do reflect the accurate, or reasonably reflect the accurate position. They reflect features on the ground. The common problem, particularly in the laying out of building estates and new developments, and when I say new developments, I mean new developments when they were laid out, so even developments in my experience go back to the 1960s, is that builders and developers would draw up plans for the location of where buildings were going to be and where boundary fences were going to be located. There would then be a building out of the estate, and those original plans would be used for the transfer of parts, TB1s, or for the first registrations, without any regard to the fact that the builder might have changed the location of some of the fences or modified their plans somewhat. And so the purchaser literally is not necessarily getting legally what they see. And this was a point which was discussed actually at the time the Land Registration Act was being debated in the House of Lords. And Lord Goodhart used just such an example to seek to remove the third condition from what became the Land Registration Act 2002, saying that these sorts of disputes ran up huge costs and wouldn't the general boundary rule do. And the problem, as Baroness Scotland pointed out to Lord Goodhart, as Gavin MacLeod observed in his seminar, is that the general rule simply sends people back to the earlier transfer, and that the effect would therefore be to, of not having the third condition, would be to lock in those sorts of mistakes indefinitely. At least the third condition rectifies the situation after 10 years, because by then the fence will become effectively both the possessory and the legal title. And so instead of resolving disputes, Lord Goodhart's proposal of disposing with the third condition would have made for a different sort of dispute, and potentially one with much harsher consequences. The debate in the House of Lords, though, worked on the basis that adverse possession relates to land within the general boundary rule. Now, the general boundary rule, as has become clear in cases like Drake and Fripp from 2011, can encompass some very large areas of land indeed. So that potentially would have mitigated some of the issues about the extent to which one could have avoided the need for the third condition by an application of it. But I think the real effect, had Lord Goodhart had his way, might have been quite different. And I think it's probably like this, that common lawyers wouldn't have liked the harsh rule which he would have imposed, whereby you only get what the transfer says, irrespective of what you've seen and irrespective of 10 years or more of possession up to the identified boundary feature. I think common lawyers wouldn't have liked that. I think common law is a bit like a balloon. You squeeze it in one place and make the rules stricter in one place, and it bulges out in another. And what I would envisage, had the third condition not been introduced, is in fact something rather similar to the third condition itself. I would envisage that the courts would have declined to make injunctions or to grant possession where it was manifestly unjust or disproportionate to do so. In other words, there would have been a sort of de facto and less structured adverse possession. And in fact, that is what can be seen in some of the cases in any event. So Gavin McLeod mentioned the case of Derbyshire and Fallon from 2007, decision of Michael Mark in the first, then as Deputy Adjudicator of the Land Registry, who would now be called a judge of the first tier tribunal. And there was a general boundary shown, but it was somewhat inaccurate. And the local authority wanted it to be corrected to its more accurate position. And that's a matter of alteration rather than rectification, because no title changes, you just get a more accurate plan. The High Court upheld the Deputy Adjudicator's decision that I just explained, that is not rectification, it's just alteration, but also upheld his decision not to make that alteration because the boundary had already been built over and it would just cause confusion. There was a de facto right of possession in that case. And frankly, had the law developed along those lines, we could have abolished all three conditions without necessarily working so serious an injustice. But we have the third condition, and it is the third condition which is the way in which these cases are almost invariably argued. And it can be seen, for a start, the third condition is not limited to the land within the general boundary rule. That's not what the Act says. That's not how it is applied. And that begs the question of how much land can be claimed under the third condition. Now, it seems to me that there are two ways in which this is limited. The first one is in line A. The land to which the application relates is adjacent to land belonging to the applicant. And the best case on that is Mr. Justice Fancourt's decision in Dowes and Bradford Metropolitan Borough Council. Now, he did give some consideration to whether or the extent to which this related to the general boundaries. And he says that is clearly the case when the land is in dispute within what would be regarded as general boundary area as between two parcels of land. So this condition is plainly applicable in those circumstances. It's not the case where only a small fraction of land is in dispute adjoins the applicant's land, as in the case here. Claim to adverse possession of the greater part of the disputed land does not adjoin the boundary and can have nothing to do with the position of the boundary between the two parcels. Even if the claim succeeds, the disputed land does not become part of the applicant's land, thereby changing the boundary. The applicant is substituted as registered proprietor of the owner's land, and the boundary between the parcels remains unchanged. So if you're within the general boundary rule, all good. But one can see the complications if you're not. And these are the plans which show some of the land. So here we have the Bradford MBC title, which is very big, running around the outside of this estate. This is the land which is claimed by adverse possession. And this is, and properties, one of the properties edging onto that land was the property of the Dowes family. And one can see that why the judge said, well, that is not adjacent. And so that's not adjacent, so you can't come within the exception under the boundary. We also have the case referred to there, case of Monk and Gillespie, not Thelonious Monk and Dizzy Gillespie, from 2021. And that's quite an interesting comparator, because what happened there is there was a strip of land 16 to 20 meters wide at its widest point, which wrapped around two sides of the applicant's agricultural field. And what Judge Bastin found was that that strip of land did not dwarf the land owned by the applicant in the way that the Dow's land did, and was held to be adjacent to it. So the adjacent test does not limit the amount of land claim hugely, but it does stop huge claims being advanced to adjacent lands and indeed adjacent titles. The other qualification is under paragraph C. The applicant reasonably believes the land to which the application relates belonged to the applicant. Now, the size of the land in question is plainly relevant to reasonable belief. Reasonable belief was touched upon by John Aldis, so I intend to be quite brief about this, but I thought it might be useful just to look at some of the cases which have come before the first tier tribunal in relation to reasonable belief. If the applicant didn't have that subjective belief, so they didn't have the belief themselves, then they lose. Obviously, that means that ignorance, there's a premium of ignorance, which is effectively the comment in Webb and Bernard. That's the other side of the coin. In that case, the applicants have been advised and solicited in 2010, 2011 of the true position, and so it was too late to apply in 2017. If there's no evidence either way of subjective belief, then the applicant loses. If the applicant admits they can't remember what they believed at the relevant time, they lose. That's Mayhew and O'Connor. If they never even thought about it, Tomlinson and Foster, they lose. And then just for completeness, if they've got co-owners, co-claimants, I suppose, and you have evidence of belief from one applicant, but not from the other applicant or a relevant predecessor, then again, the claim is defeated. Then the other aspect of the subjective belief is that the land belongs to the person applying for applying for adverse possession, and it has been observed, and it's worth bearing in mind, albeit obiter in the case of Dow's, but not obiter in Crosdale and Hodder, that you don't have to believe that you have paper title. All you have to believe is that that the land belongs to you. And so again, if you get your 12 years in, or you believe you've had your 12 years in before 13th of October 2003, that is enough. In Crosdale and Hodder, the position was that a previous possessory title had been obtained, but then had been cancelled, and the applicant hadn't realised it had been cancelled, and they were found to have continued to have that reasonable belief that the land in question was theirs. Then we get the objective aspect of reasonable belief, and this really goes to the central problem in relation to the third condition, and that is if the extent in which you are, if you like, trespassing on your neighbour's land is identifiable by comparing the registered title plan to the land with the features, and is so great as to be outside the general boundary rule, then how can the belief that you own that land be objectively reasonable? Put it another way, if you can find out that you don't own the land by looking at your garden or your field or whatever it is, and paying your £6 to get your registered title and your plan, then how can you reasonably believe that land which was not in your title and not within the general boundary rule was yours? Well, you can, and it has to be said that I think the tribunals and the courts are really quite generous about this. So Tar and Ahmed is a case from 2009, These cases, I should say, were detailed to me by Judge Patton in the tribunal, but he was doing work which I'd done in relation to similar cases, analysis of similar cases, upon which I spoke a few years ago. And Tartan Ahmed is a really interesting case in that respect. It was garden land, but the adverse possession was to 3 times the size of the garden, which was actually within the paper title of the applicant. And the applicant succeeded. He succeeded because he established his reasonable belief, or he established that his belief was reasonable, that he owned land up to a line of conifers. Seem to be quite a lot of lines of conifers out there. People seem to plant them as close to the boundary as they can. The fence on the far side of the boundary then rots, and then people make assumptions of conifers are the boundaries, and that does seem to be a regular feature. Anyway, the line of conifers was deemed by the judge to be an eminently reasonable assumption. And he said that although a careful study of their filed plan would have revealed the discrepancy, I think it was reasonable for them to accept the word of the sellers as to where the western boundary of the property lay. The position of the boundary as per the filed plan could be verified, but only by using the houses on the neighbouring road as guide, not immediately apparent on the ground. Zarb and Parry, another garden case. There the trespasser was a barrister, but she had a surveyor's report which said that the land in question was hers. The surveyor was wrong, but it was reasonable to accept what the surveyor had said. And then we have Osborne and Lawton, another case of Michael Mark. A person who buys a home with a garden is acting reasonably in the ordinary case if he proceeds on the basis that what he sees is what he gets. The question is not whether a better informed or advised person might have come to a different view, is whether the applicant's belief was reasonable or unreasonable. And then Rowland and Morris, Judge Payton, last June, that was another garden land case, another row of trees, and where the applicant was successful up to the row of trees, but not successful to the fence on the far side of the row of trees, the respondent having demonstrated that that had been built fairly recently to keep dogs out, and that he regularly stepped over the fence to maintain up to the line of trees. I'm not going to go into I.am. And Chowdhury very much, but again, it shows generosity in respect of treatment of neighbouring properties. That was one where there was upper floors were occupied when the titles revealed no flying freeholds, and Mr. Chowdhury's relief was taken to be reasonable. He wasn't imputed with what his solicitors might have known, and you will see that if you read the case, that he was treated with, I think, considerable generosity. I suspect that one of the reasons was that he'd been there for a very long time, but it does set what some people have described as a very low bar in relation to what constitutes an objectively reasonable belief, occupying land over land in question. Fields, Lorry and Harpserve Limited is an interesting one that went the other way. What is not a reasonable belief? I've described the disputed land as finger, but it may perhaps also be described as sticking out like a sore thumb, being in effect a narrow strip of open agricultural land surrounded by houses on each side. So it was in the exclusive possession of the farm between 1995 and 2008. He had previously rented it and bought it, but his relief was not considered reasonable. Looking at the plans of purchase or otherwise, or afterwards, even a cursory glance would have revealed that the disputed land was not his. It has to be said that that case now might also fail on the basis of the land being or not being fairly described as adjacent to the land in question. So I've thought about the generosity of the tribunal and the court in relation to what's objectively reasonable. How, as an advisor, would you investigate that particular question? Well, a claim to land is not going to be adjacent to the land owned by the claimant if it is extravagantly large, or if it's dwarfing the land in question, or if it bears no obvious relationship to that land and that's sticking out like a sore thumb point. Those sorts of cases will obviously fail. But in the case of domestic gardens, or even neighbouring properties in developed areas, the courts and the tribunals are more likely to give a generous interpretation, so long as the claim is to relevant features, or features which might be thought to be relevant, and even if that means that there's a substantial increase in the area of land available. And again, in relation to agricultural land, where you're dealing with large areas and the general boundary rule is quite generous, then you might expect that also to be reflected in the area of land that can be claimed. But when it comes to the bottom line, in truth, there's simply no substitute for an advisor going out there and having a look, because that is exactly what a judge will do. And a judge will apply a degree of common sense, and it might be generous in terms of gardens, and it might be generous in terms of built-up areas. But if it looks wrong, frankly, it probably is wrong. And that is not necessarily a very satisfactory legal way forward, but is the way in which adverse possession under the third condition is typically being applied. And so, how much is too much? Well, the neighbouring title is too much. It's got to relate to the boundary, and it's got to withstand an ordinary common sense layperson view regarding what you see is what you get. So that's the end of my script. If anybody has any questions they would like me to address on any of the points that I've raised, then please do feel free to put it in the chat message area, and I will do my best to respond accordingly. I haven't got any in the chat at the moment. What I'll do is I'll just stop sharing so that it might become more apparent. As I say, while I'm just waiting whilst anybody formulates any questions in relation to this, this seminar and the preceding seminars by the real estate team will be available shortly, so they can be viewed remotely as part of internal training, or to catch up if people missed the beginning of this talk. Otherwise, I'm going to give another minute for any further questions. Otherwise, I will conclude matters and thank everybody who has attended for lending me their ear. So thank you very much.